So, I came from a little wheat and cattle operation in Leedy, Oklahoma, and we've got to deal with the very issues that we're talking about today. We have proven that our land is incapable of producing oil and gas. We have a couple of dry holes to prove that to you. But we have got to deal with some of the surface issues as well. And so, I've had a little bit of personal experience with this, but we recognize that all landowners, especially in northwest Oklahoma, but especially in Woods and Alfalfa County, where if you love the program so much you want to see it again, we're doing the exact same show in Cherokee later tonight. But these issues pop up a lot, and we recognize that oil and gas prices may not be what they were a couple of years ago, and some of that activity's cooled off a little bit, but two things. Number one, smart money says those prices will come back at some point in the future, and so there's probably going to be a lot of interest in this region once more. And number two, some of the oil and gas companies that were in a good cash position are actually looking at this as an opportunity to snatch up some bargains. We're all for them getting bargains. We just don't want you to be that bargain. So if somebody does come back around and wants to lease some land from you, we want you to kind of be armed with all the information that you need. So, having said that, one little caveat. Ever since I was a 9-year-old in 4-H, the criticism that came back on all my speeches was that you talk too fast. Being a lawyer and an auctioneer has not helped that, okay? Number two, this program we gave in 4 hours at College Station earlier this week. I've got 2 hours because Dr. Hallahan's going to take our third. So we're going to go fairly quickly through a lot of this stuff. But I'll make you a deal. Number one, all of our slides are there in that handout for you. And number two, pursuant to the grant that we got, we actually have an Oklahoma Oil and Gas Issues Handbook for you. That handbook is just going through the final stages of being polished for publication right now. So if you will go to the OSU Ag Econ website, which is just agecon.okstate.edu, and if you'll click on extension there, we will have those materials posted for you, hopefully in the next couple of days, actually, at least hopefully by early next week. So that should all be there for you. The whole handbook is out there for you to work through at your pace, and the handbook contains a little bit more detail about what we're discussing today. Has lots of bullet points, or if you want to think of them as checklists, things for you to go through as you're considering, what should I have in my surface use agreement? What should I have in my oil and gas lease? If I've got a pipeline right-of-way agreement, or if I've got a seismic permit that I'm talking to with a oil and gas company, things for you to consider are there. We've got some examples of those types of agreements there. Not saying they're great, not saying they're bad, just saying there's some examples for you to see what those things tend to look like. So with that, I'll quit talking about what I'm going to talk about and just talk about what I'm talking about very quickly. And I know, oh yes, yes.
I left out the announcement that we will have a break about 2:45, and I'll have snacks, and there's drinks up here if you can't wait for the break, so just feel free, but we will have a break and snacks here in a little bit.
Yep, and at 2:45 we'll take the break. They'll give you guys a chance to stretch out, do whatever you need to do, and then that'll give us a chance to switch over to Dr. Hallahan's materials as well. So real quickly, I'm going to give you an overview of the oil and gas industry. I realize this may be stuff that lots of Oklahomans learn when they're 5 years old, but I kind of want to do it just to help frame up some of the issues that we're going to talk about as we move on to the later parts of the presentation. Probably the first thing you encounter, whether you're a mineral owner or a surface owner, even in some of those cases, is that there's going to be a this is an unfortunate coincidence, by the way, seismic exploration of the property. And when we talk about seismic exploration, honest to goodness, what we're trying to do is give the Earth a sonogram to see if it has an oil and gas baby. That's really what you're trying to do, because you set off either explosive charges or you use vibration trucks, you might see them also called vibro-sized trucks, to create vibrations. Very sensitive sensors called geophones are laid across the surface to see how those vibrations reflect off of the formations underground. And by detecting the changes in the speed and direction of those vibrations, you start to get an idea for what formations are underneath the surface. Certain formations tend to capture oil and gas a little bit better, or have oil and gas entrained into them, and that's what tells you what you're looking for. Now that kind of beats the old method where you go out with water witcher sticks and just kind of hope you would walk over an oil and gas formation and your sticks would cross, right? Or you drill a wildcat well and hope that you struck something, and if you didn't, boy, you spent a lot of money trying to figure out if there's anything down there. So that science has gotten a lot more precise. And if we've got a promising formation down there, then you'll probably be approached about having someone drill a rig on the property. Now that's going to start with the creation of the pad, which is just create a nice level and stable surface for all the equipment to be rested on. Then after time, you'll start to see some of that equipment come onto the field, get it staked out, get the well site specifically located, and then you actually have the erection of the rig, which that's going to take, several trucks worth of equipment just to get the rig up. And that's if you're just dealing with a good old-fashioned traditional vertical well. If you're talking about a horizontal well, there's a little bit more involved, and we'll talk about that here in a second. You guys have probably all seen diagrams like this before, but really what you're trying to do with the derrick is you're just creating a framework for a drill bit. Just think about the derrick as being a big drill, okay? And what you're doing is putting a rotating bit on that drill stem pipe, and we've all seen that. That rotates down, and as it rotates down, the teeth kind of chew into rock. Well, what happens to the rock then? You got to have some way of getting the rock out of the hole. That's where drilling mud comes in. Drilling mud is actually piped out of a pond or a tank and through the hollow stem of that drill pipe. That cools the bit down because it gets pretty hot down there. It flushes that rock that's been cut up and out of the well, and it also provides pressure. It provides hydraulic pressure against the hole that you've made so that it doesn't want to collapse in on itself. Now, in this part of the world, you guys have probably encountered some drilling mud in applications to your property. Have any of you guys been approached by someone to apply drilling mud to your place? Seen a few nods in the audience. Yeah. So that's where that comes from. So the drilling mud may have come into contact with some hydrocarbons that are down there in the well. It may have some salts or some other stuff attached with it, and of course it's got some rock. But it's also got some of the stuff that's part of the well fluid, right? Something that's been added to give it some viscosity, something that's been provided to add some density. Sometimes that can be good for your soil, sometimes it may not be as good. Now, especially in this part of the world, lots of the oil and gas is in shale formations. And if I drill a hole vertically, I'm only going to intercept, a few feet of that formation. And those formations aren't very permeable. So let's talk about where you find oil and gas for a second. When I was a kid, I thought that oil and gas was in holes in the earth. That the earth kind of looked like Swiss cheese, and there was oil in the holes in the cheese. All you had to do was find one of those holes and suck it up. It's kind of like that, but the holes are a lot smaller. What's probably better to think of the earth as being kind of a sponge. And certain rock formations have bigger holes than other ones. And the bigger the holes, the easier it is for oil and gas to flow towards where your well is. But in these shale formations that we have around here, it's not very easy. It's tough to do. So you need something to help make it easier for the oil and gas to flow to the wellbore. So two technologies really help out a lot with that. Number one, horizontal drilling, which we've had non-vertical wells for, 60 or 70 years. But only in fairly recent times, since the 1990s, have we really had the technology to take a well down and then almost make a darn near 90-degree turn to go horizontally. If our formation looks like this, okay, if it's fairly thin vertically, but it may stretch out for miles horizontally, a horizontal well comes into more contact with that formation. Number one, that helps get the oil and gas to the wellbore. And then number two, we have hydraulic fracturing. Hydraulic fracturing is really what the name implies. You're using hydraulic pressure to try to crack the rock open and create more pathways for that oil and gas to get to the wellbore. Now, the biggest component of that hydraulic fluid that we use in most cases is water. Water makes up a big chunk of that hydraulic fluid, and then we use an exotic material to hold open the cracks that are created in the rock. Many times that exotic material is sand. It's just sand. Sand's kind of coarse and grainy, and if we use that hydraulic pressure to crack the rock, the sand and the fluid sticks into the cracks and holds them open. There's lots of other materials in that hydraulic fluid, everything from acids in some case to help eat away some limestone that might be in the formation. You might even have some antiseptics, believe it or not, because bacteria want to grow anywhere they possibly can. And so sometimes you can even create cracks in rocks thousands of feet under the surface, and you get bacteria growing there. So the biocide or the antiseptic helps kill the bacteria so they don't clog up the pores that are actually helping the oil and gas make it to the wellbore as well. Hydraulic fracturing takes a lot of pressure, takes a lot of fluid, and so what you'll see on a hydraulically fractured site is lots of these trucks, backed up to a manifold, so they're each contributing fluid and pressure to that well for a certain period of time, and that pressure is applied through the Christmas tree you see there to create those cracks, and the pressure is let off. Now, when you let off that pressure, in many formations, you get the water back that you pumped down there. That's what they call flow back. So I've put it under pressure, and we all know that if you put water under pressure and let the pressure off, it comes back at you. So that's flow back. But then what you also get is produced water. Produced water is salt water that was part of that formation that you've now relieved the pressure on, so the salt water can flow up along with the oil and gas as well. That's one of the biggest issues that we've got in this part of the world, is that these formations are good at producing oil and gas after they've been fractured, but they also produce a lot of salt water. And what do you do with that salt water? Well, you could evaporate it and try to dispose of the salt some other way, but that gets to be pretty expensive. So the other thing that you could do is you can re-inject it through saltwater injection wells, which traditionally in Oklahoma is how we've done a lot of our saltwater disposal. But that's what's led us to some of the questions that we've got about what might be some of the side effects of that saltwater disposal, i.e., is that what's causing earthquakes? And that's something that Dr. Hallahan will talk to you more, so I'll leave that for him. One more thing to mention about hydraulically fractured and horizontally drilled sites, because there's more equipment on site, the well pads tend to be larger. And from my conversations with folks in the industry, I've seen that those horizontal pads tend to be about 4 to 5 acres. Is that relatively consistent with what you guys have seen in this part of the world too? So a little bit bigger than a traditional vertical well because it needs to be bigger to support more equipment out there. Now, once the well's been drilled and we've got a well completed, casing goes down the well, and you'll probably see some equipment on site, whether that's a tank battery to store oil. You might see some treating equipment to perhaps pull the water, oil, and gas apart from each other, a separator. You might see some sweetening units. Sweetening units try to get hydrogen sulfide gas out of the natural gas. That stuff's nasty. You don't want it in there. You don't want to breathe it. You definitely don't want to send it to market either. So you'll see some of the equipment on site. And one thing I want you to notice too is that in addition to the equipment, you might see a disposal pit on site to handle things like sludge or salt water or things of that sort. But you'll also see, hopefully, some barriers around the equipment so that in case there's a spill, there's a second line of defense to catch that spill before it goes off-site there. So what are the potential impacts to the surface, anyway, from having oil and gas production on the property? You know, number one, obviously you physically lose the land a little bit. You've lost that 4 or 5 acres that's underneath the pad. But there might also be land that's underneath roads. You may have lost some access to some property. Even though the property's still untouched, it may be difficult to access without getting across the well side or the pad or something like that. Come on in. Changes in access, which might actually be a good thing. You might actually get some roads that you wanted to have on your property. That's one of the benefits that we got to our land. We didn't get any royalty checks, but we did get some nice roads that gave us access to our property in all seasons that we didn't have before. So that can be a positive. On a negative, though, sometimes that might change the way you access your property. It might cut off a road that you had before. If you've got, for example, an irrigation pivot on the property, there might be some impacts to how that pivot operates as well. Modifications to your fencing or gates. Sometimes new access roads are needed, so that means that there's a new cut in the fence that we have to put a new gate through. And by the way, I'm a big fan of, actually fixing the fence if you cut through it. We have this marvelous technology in agriculture that allows us to pass through fences unharmed. It's called a gate. Let's have one of those put in place, maybe even a cattle guard. That's even more advanced technology, right? But let's make sure that we take care of that. There might be some rights of way across your property, and that might be for a pipeline that might connect your well to a larger pipeline or something like that, or maybe a gathering pipeline that connects product from a few wells in the area. Electrical lines, pipelines are also things that you might have to contend with on the surface. We're probably going to talk about those a little bit later on when we mention rights of way. And then if there are spills, that's obviously something we have to deal with as a landowner. Now, in my conversations with lots of landowners, I see that a lot of the concerns that they have are what happens underneath the surface, especially with hydraulic fracturing. Hey, you're injecting all this stuff at high pressures. What's the risk that that's going to contaminate groundwater? most of the academic research that's been done, especially on hydraulically fractured wells, indicates that there's really not a whole lot of risk of contact with groundwater so long as the well is being constructed to the Corporation Commission standards, which there are standards for pressure testing of the well, for the types of casing, the specifications of pipe. And generally, these operations are taking place way below groundwater level. In most cases in western Oklahoma, thousands of feet below groundwater level. So the greatest risk really isn't underground, it's at the surface. And you've got the transportation of materials to the well site. If there's a spill there, your odds of contact with surface water are much higher, okay? Or with contamination of a near surface aquifer. So spills at the surface are actually probably the greatest risk that we have, both to water quality and to soil quality. If there's a oil and gas spill there, or the gas spill, sorry, oil spill. Gas spills are fairly easy to clean up as long as no one lights a match, okay? Those kind of tend to take care of themselves. But oil spills obviously have some cleanup issues there. And then there can be some issues, especially some soil impacts, from surface disposal of drilling fluid, applying drilling mud to your fields. And we actually have some research going on at OSU right now to figure out exactly what those impacts are. Dr. Chad Penn in the Plant and Soil Science Department at OSU actually has some research plots at Lahoma where they've been applying drilling fluid to the fields and analyzing the impact that it has on grasses and on wheat crops. And what we've kind of learned there is exactly what we would expect. With the salts that are in the drilling fluid, you need good precipitation events to leach those salts out of the top layer of your soil profile and down to the sublayers. And once that happens, after a few years, crop productivity appears to be returning. But those first couple of years, soil productivity is going to take a hit. And if you're in a drought mode, there's nothing to leach those salts out of the soil, so that really prolongs that process. So having said all that stuff, if you're following along in your evaluation form, we just talked about the impacts of oil and gas development to your property. So did we talk about that? Yes or no, right? Now, let's talk about negotiating surface agreements. And when we talk about surface agreements, we're kind of lumping several things together here. We could be talking about a seismic permit for someone to explore your property using seismic methods. We could be talking about the surface use agreement under the Surface Damage Act that we've got in Oklahoma. Or we could be talking about, a number of other potential things like land application of drilling mud. That's another thing that can impact the surface there as well. So one thing we have to think about, and again, most Oklahomans are familiar with this, but don't feel bad if you're not. In Oklahoma and pretty much every other state in the union, we can separate ownership of the minerals from the surface. So one person might own the mineral estate and another person entirely might own the surface. Well, when we do that, we create what we call severed estates. The surface and the minerals. The mineral estate is called the dominant estate, and the surface estate is called the servient estate, which sounds like fancy legalese. What does that mean? How do you get at the minerals? You got to go through the surface, right? And so with the surface has given an implied easement. It's not written out, it's not part of your deed. There's just an understanding in the law that the surface is going to have to let the minerals have access to their minerals. So that means that it comes with some burdens there, and that's why it's called the servient estate. The surface owner is probably going to have to allow seismic exploration for the mineral owner to figure out, is there anything underneath there for us to produce? Okay? So there's a seismic element to it. If there is a good probability that there are minerals there, they're probably going to have to permit production activities, which means allow a well to be drilled in the surface. Then they'll have extraction activities, which means we actually have to get that oil and gas up and out of there and to market. So that means the surface owner kind of has to put up with some stuff. But that's balanced in Oklahoma by the Surface Damage Act, which is, in the scheme of things, actually relatively new. It just came along in 1982. And the trick was, before 1982, the rule was, so long as the amount of damage that the operator did to the surface was, quote, quote, reasonable, whatever reasonable means, and reasonable means whatever 12 people on a jury says it means that given day, right? So unless the damage wasn't reasonable, the mineral operator owed nothing to the surface owner. Well, that led to some litigation because The surface owner always thought that the damages were unreasonable, and one could kind of understand how they would get that perspective. So there was lots of litigation, lots of operators being greeted at the farm gate with shotguns. We thought that wasn't that great of an idea either. So we came up with the Surface Damage Act, which provides protections for the surface owner and says, surface owner, you're entitled to payment for the damages caused to the surface of the property by the oil and gas operations. And the measure of those damages, and I'm shorting things a little bit here, but are basically what was the fair market value of the property before the operations, what was the fair market value of your property afterwards, and the difference between those two. That's what you're entitled to in surface damages. Now, one thing that's important about the Oklahoma rule is that the courts have affirmed that we're not just talking about the land that was taken. In other words, the land underneath the road, the land underneath the location. But what we're talking about is the holistic impact to the value of the entire parcel of property, even if it's beyond the area where the operations occurred. So that's an important thing to figure out. But what you also need to figure out is, do I own the minerals under my property? Some of us know that, some of us don't. So how can you figure that out? Number one, you can always ask the oil and gas company, hey, you guys have done the mineral work. Who do you show is the owner of the minerals underlying this property? So that's probably the easiest low-hanging fruit there. But you could also check your title insurance policy if you got one of those when you acquired the property. Now that works if you'd acquired the property yourself. If you'd inherited it, and you inherited it from somebody who inherited it, who inherited it, and who inherited it, you might have to go do a title search or maybe do a mineral abstract. And that can be a little bit pricey, but you may already have a mineral abstract in your land records somewhere. And that can help you figure out, all right, exactly what part of the minerals do I own. You really want to, you can hire a landman. The landman can do a little bit of the title work for you, or, heaven forbid, you actually hire an attorney, and they can give you a title opinion on the minerals. And that might actually be worth your while as well. How do you figure out how this is going to impact your property from an economic standpoint? Because there's probably going to be an impact, right? Well, we have this nifty little tool in ag economics called partial budgeting, where if you're not completely changing everything about your farm, you're just changing a piece of it, partial budgeting will show you kind of what that economic impact can be with respect to what you are changing. So in partial budgeting, number one, figure out the revenues, which is what you guys probably came here to talk about, right, is revenues. And I don't blame you a bit. I'm an ag economist. I'm all about revenue. So what am I getting paid, okay? What are my surface damage payments? That's supposed to be the thing that makes me economically at least as well off as I would have been if you guys hadn't showed up and drilled the well. But are there the potential to sell any resources to the developer? Might you be able to sell water or gravel or even services to the operator? Heck, I've heard the story of one landowner that not only got their surface damage check, but they also owned a bulldozer, so they did a lot of earth work for the location. This landowner's spouse made pretty good cinnamon rolls, so they catered breakfast to the location. And they had a cabin on the property, so they actually rented the cabin to the company to put up some of the guys that were working on the location. That's thinking entrepreneurially, folks. That's okay. You can sell them stuff too. So you've got that to increase your revenues. On the reduced cost side of things, and lots of people look at me like a Cocker Spaniel, like, huh? You say, reduced costs? How's this going to reduce my costs? Well, technically, especially if I'm actively cultivating this land, I'm not cultivating that 5 acres anymore. So I've got less seed, less fertilizer, less machinery time, less labor time on that. So that should reduce our costs a little bit. Now, on the other side of the equation, what are our decreased revenues? So if this is cropland, I've lost 5 acres of cropland productivity. If it's grazing land, I've lost access to, say, 5 acres of grazing capacity. So I've got that on my decreased revenue side. And on the increased expenses side, sometimes it's more expensive to farm around stuff. Ask my friend Matt. Matt is an engineer/farmer. Farms everything with GPS and RTK so that all he has to do is kind of make a turn every once in a while on the tractor. He hates obstacles in the field. Hates obstacles in the field. And I will say I wasn't really fond of them when I was driving a tractor either, but that does increase our expenses a little bit. So in partial budgeting, all we do is on one side of our ledger, we take into account the things that are adding income and reducing expenses, so that's increasing our return to land. Then on the other side, we've got the things that reduce our income and increase our expenses. Those are things that decrease our returns. Where those leave us on balance, that's what the net impact of the operations on our property are going to be. As an economist, the right answer, quote, quote, to your surface damages is what makes that zero. Now, as a landowner, the right answer to that question is what makes that significantly greater than zero, right? You don't want to come out even. You'd like to come out a little bit better off if you could, right? So that's one of the things that you need to bear in mind there. So that's how partial budgeting can be used to help you evaluate whether or not this can be a potential gaining proposition for you or not, or at least how you minimize that damage. Let's talk about seismic for just a little bit. Now, seismic's pretty straightforward in that we create vibrations on the surface and try to use those reflections to figure out if there's oil and gas there, right? And in most of the circumstances, it's cheaper for the oil and gas company and probably better for us if we use the vibration method, the vibro-sized trucks that just create vibrations on the surface. Shot hole operations, or operations using explosives, can be a little bit more dicey. And they're usually a little bit more expensive, so they're not used as frequently as vibration. But when they do happen, sometimes you get some impacts from the shock of those detonations. One thing that landowners have often reported is that if they have a well that's pumping water from a fairly sensitive groundwater formation nearby, is that they've noticed that the flow of that well may decrease a little bit. It may have what we call increased turbidity. That's a fancy word for there's stuff in that water I haven't seen before. Okay, it's a little bit more cloudy. There's more stuff in it, more solids. So those are things that can happen. Sometimes, too, you might have some surface impacts. There might be detonation cords left on the surface. You might have some unfilled holes sometimes if the operator's not conscientious about putting those back in. And, of course, if it's wet, you might have some rutting, especially problematic if you're on a cropped area. So those are things that you might see from seismic exploration. So as a result of that, when someone approaches you for seismic exploration, one thing you might do is say, hey, I've got some sensitive areas on my farm that I'd like you to steer a little bit further away from, especially water sources, okay? Water sources may be one thing you wanted to find a setback from. You might have a specific distance that you don't want any shot hole operations. Again, shot hole operations using the explosives to create the vibrations. You might want to set a certain area around those. Some examples of what those distances are might be if it's a normal operation, 300 feet. That's what lots of landowners that I've talked to have used as a guide. And then if it's a shot hole operation, again using explosives, sometimes they'll set that at 660, which I believe is 1/8 of a mile if my math is right. Anybody good at doing that in your head? It's a decent distance, right? If you can pull it off. One thing that's kind of nice is if you can have a seasonal restriction of when the seismic activity takes place. In other words, can we avoid doing this during a growing season or maybe during a time of the year when I'm going to have livestock in a particular cropped area? Sometimes you can pull that off, sometimes you can't. If an oil and gas company is doing a major seismic survey, they may be surveying hundreds of square miles at a time. That requires the mobilization of a lot of equipment and a lot of people. And that's hard to do, start, stop, start, stop, start, stop. They might need to start somewhere and just go through in one motion. So you may not be able to negotiate a seasonal restriction in your seismic permit. Cropping periods, livestock use, we've talked about those. Restricting access points. You might be very specific to say, look, I'm happy to let you use my land for seismic exploration, but let's define where you enter and exit the property so that we don't have fence cuts or other stuff like that. If we do need to have a cut, how are we going to brace it? What kind of replacement fence are we going to use? If we need to install a new gate, what are those specifications going to be? No fence cuts, please. And if you sense that I'm sensitive about the fence cut thing, remember, I'm a farm kid. The one thing I hated more than building fence was rebuilding fence. So this strikes a very personal chord for me. Then it was fence, rebuilding fence, and then working cattle. Just because of the language my father tended to use on me in both of those circumstances, right? Make it easy for the company to do the thing that you're asking them to do. If you've got sensitive areas that you'd like them to steer away from, grab an aerial picture of your property. And that's easier than ever to do because all you have to do is Google it, right? By the way, Google Earth is a software package made by the people that bring you Google. Fantastic tool for what we're talking about today. Great aerial imagery. You can pick the area. You can draw stuff on it. So what you can do is, for example, define your crop areas or your homestead areas. Set those apart. You might define the setback distances. If you want to know what, let's say, for example, 300 feet from a house or a water well look like, that's what 300 feet looks like. If you want to define 660 feet, that's what that looks like up there. These little green spots here, those are gates. That's where you have access to the field. Green indicates crop areas. Make it as easy as possible for these folks to do the thing you're asking them to do. And as one of my friends who works in the oil industry told me, Ferrel, sometimes the people in charge of these crews are folks that have master's degree in geophysics. Sometimes they're not. So, sometimes they don't have advanced degrees in geophysics. Sometimes it's the guys that you found, right? So let's make it as easy as possible for either a geophysicist or somebody who's not a geophysicist to do the stuff that you're asking them to do. Now, real quickly, Oklahoma has seen some fairly recent changes in the law with respect to seismic issues. Seismic permits, that is. It used to be that there was not really a requirement for the seismic company to provide you notice before they did exploration on the property. It was fairly restricted. But since 2011, we had some major amendments to the Seismic Exploration Regulation Act, or SARA, S-E-R-A, Seismic Exploration Regulation Act. Whew, take a breath. Okay. As part of those amendments, number one, you have to get notice at least 15 days prior to anyone doing seismic exploration on your property. Number two, you're required to be offered a seismic use agreement for your property. That's also supposed to pay you for the use of your property. That's a big change. That's nice. Because it used to be that there wasn't any requirement that you be offered compensation for the use of your property. So those are two very significant things. Here's the catch. You receive that offer at least 15 days prior to the entry of your property to do seismic exploration. They're required to offer you compensation for that, and you can negotiate other terms in addition to the compensation. So no problem there. However, if you reject the offer that they've made, meaning you say, nope, that's not enough, I don't want it. Or, number two, if you don't respond in 15 days. In other words, you put your hands in your pocket and you don't do anything, you're deemed to have rejected the offer. In so doing, they now have no obligation to pay you unless they cause, big air quotes, unreasonable damage to your property. And the only way to prove that is to either take them to small claims court or to file a full civil trial. If at trial you're awarded less than was offered to you, not only do you get less money, you also get to pay all of their lawyers' fees, court costs, everything else. Now, on the other hand, though, if you get more than they offered, they pay all of your court costs. So it's kind of a risky proposition there. But the good news is you have some rights when it comes to seismic exploration. You can be proactive in negotiating that. Just remember, if you get a notice from an oil and gas company, don't do what everybody else does that I see in rural Oklahoma, which is put it on the dashboard of your pickup and hope that it mellows out for a while. That's not going to work for you. You got 15 days. By the way, 15 days from the day they postmark the notice. So the clock's already running even before you get it in your hand. Remember, folks, legal notices do not age like wine. Legal notices age like milk. Just remember that, okay? They're not going to get sweeter. They're going to get more sour the longer you hold on to them. So that's the seismic side of things. Let's talk about surface use agreements, okay? And like I said, with the surface use agreements, we've got the protections of the Surface Damage Act. Surface Damage Act says that we're supposed to provide the landowner with an estimate of the damages, by the way, before anything takes place, okay? Ideally, under the Surface Damage Act, you've got a surface damage agreement and a check in your hand before the operations take place on your property. So that's kind of a big change from the way things used to be, and it's very positive for the landowner. Now, if you can't agree in advance to what that payment should be, then the oil and gas company is going to go to the district court and ask the court to appoint appraisers. Here's how the appraisal process works. Landowner picks an appraiser. Oil and gas company picks an appraiser. Those two appraisers get together and they pick a third appraiser. So you're going to have three appraisers look at the property and try to estimate what the damages to the property are going to be using the guidelines that we talked about just a little bit ago. They make that report to the court. That's a second chance for the landowner and the oil and gas company to say, okay, that's what three appraisers came up with. That seems like a reasonable number. We'll accept that, sign the surface use agreement, and go on. If you don't like that, though, you can appeal it to a jury trial. And at the jury trial, the issue is, what should the damages have been? Same rule as with seismic. If the landowner gets more than what the appraisers said or what was offered, the other side pays all your costs. If you get less, you pay all the other side's cost. So again, that's kind of tricky. And these days, we really don't see a lot of surface use cases go to trial. Because really the evidence that you'd offer at trial would be you'd probably have some neutral appraisers try to evaluate what the damages were. Well, you've already done that. That's already happened. So the best evidence that you would present to the court has kind of already been presented. So that kind of makes a lot of this stuff go away before you even have any part of the trial process. Let's forget all that. We're going to negotiate a surface use agreement with the oil and gas company in advance so we don't have any of those problems. So when you're negotiating your surface use agreement, number one, what's your bargaining position? Remember, if you just own the surface and you don't own the minerals, one way or another, you're going to have to allow the oil and gas company to conduct operations on the land. It's going to happen. So that's kind of a significant minus when it comes to your negotiating position as a surface owner. By the way, if you're a mineral owner who owns the surface too, don't forget that. You're still a surface owner and a mineral owner now. And we've actually had cases that say very specifically, the Surface Damage Act applies to surface owners. Whether you own the minerals or not, if you own both, it still applies to you. So you're still entitled to all those protections. Don't get so caught up in executing the mineral lease that you forget about your surface use agreement as well. You have far more bargaining power because they don't get to the minerals without your say-so. So understand your bargaining position. If you're severed, that's a little bit difficult, but if you own a large acreage that they're very interested in, that gives you a little bit more strength there. Try to, if you can, maintain a relationship with the mineral owner. Now, in some cases, that's pretty easy. It's somebody down the road or it's somebody in your family. Although if it's somebody in your family, that might actually make the relationship more difficult, but that's another seminar entirely, okay? But if it's somebody that lives in California or New York or Florida, or if it's 20 somebodies, as I was talking to some of the guys before the meeting, I was dealing with one of my relatives who owned a 1/20th interest in a quarter of land. That's a pretty small interest there, right? So, understanding how much you've got there is important to you. Having a relationship is important. There's strength in numbers. If a lot of you can get together with your fellow neighbors and say, hey, there's a lot of development taking place in this part of the world. Let's get together. Let's even pool our funds and hire an attorney to come up with a surface use agreement that we can all use. And we'll all agree we're going to stick to the terms of this agreement. That can help out your position a little bit. Now you've got a little bit more strength in numbers. All you've got to do is get a lot of Oklahoma landowners to get together and all go in the same direction. That's all that takes, right? Any of you guys fiercely independent Oklahoma landowners? No? Okay. Everyone thinks pretty collaboratively here? Good deal. Good deal. One of my friends who does this for a living made me put this point in my presentation. He's like, Ferrel, don't leave out that bullet point. That you catch more flies with honey, right? And so often, I see it. People bow up a lot. Maybe because they don't want their surface to be interfered with, which I certainly understand and respect. Maybe they're just thinking that that's the only way to negotiate. But we all know from dealing with jerks in life, and by the way, has anybody in here not dealt with a jerk in your life? Okay, so we've got some commonality there. Good. You don't want to give jerks anything. You want to resist jerks. But here we are, being a jerk sometimes, and expecting that that's going to get us more out of the other party. And it just doesn't work that way. They've got a job to do, you've got a job to do, so the more professional you are in your communications, the further along I think you're going to get in the process. So let's talk about what we need to be considering then as we're negotiating the surface use agreement for our property. Number one, think about the environmental baseline of your property, which sounds fancy and you're like, my property ain't got no environmental baseline. Yeah, it does, okay? Do any of you have friends that sell diet products? Any Advocare sells, or if you buy this, it'll cause you to lose 30 pounds in 10 days and blah, 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 right? If you know someone, let me know because I could use some of that. But what do they always show you to sell you something? They show you, look at this fat guy, me, right? Look before and then look after. And here's this Adonis sculpture of a man, right? Before and after. That's all the environmental baseline is. What does your before on your land look like? And what's the after? So you're really trying to figure out, all right, I need to make sure that I can establish, if I need to someday, what the condition of my property was before development and what it was like afterwards. So number one, gather up all the records that you've got about the activity in the area. If you've got some aerials from a few years ago that shows what the condition of land looked like then, some aerials that show what it looks like now, gather up some of your crop production records. And if you're not a fastidious crop record keeper, at least go down to USDA and get some 5-year averages for the area to see what crop productivities look like. Look at neighboring properties. Is there anything on the neighbor's land that might already be causing an environmental impact to you? Because if so, that's one thing you're going to have to isolate and explain if you're trying to show something had an environmental impact on your property. Get the aerial imagery. Again, Google Earth is a fantastic tool for that, but you can also talk to FSA or any of the USDA agencies that can help you connect with some of that aerial imagery to show you, here's what my land looked like holistically before this operation started. That can be great not only for environmental issues, but it can also really help you figure out, for example, if we lay a pipeline here, how is that going to change the configuration of my property? If we want to figure out what a 5-acre pad looks like here, you can calculate that. And by the way, we talked about Google Earth software. Google Earth Pro is also available for free. And what Google Earth Pro does is one step further. It will allow you to measure areas on your maps and to create a lot more images. So that's a really fantastic tool. If you want to see what 10 acres looks like on your property, it'll help you measure that. And it has resolution down to the foot, so it's pretty handy. Sampling. If you anticipate that there might be any environmental quality issues, whether they're impacts to water or whether they're impacts to soil, get some baseline samples. And you can do that through OSU. We've got a soil 4-H testing lab where we can do soil and water samples. Or another place you might go is the Department of Environmental Quality. They have a laboratory services division that can provide all that sampling for you as well. But you can test that for anything to show, hey, there was no presence of salt water, there was no presence of hydrocarbons, none of that stuff was on the property before, so we've got a clean environmental bill of health there. What I will recommend to you is that do that by a state-accredited lab. Because if you need to use that sample as evidence later on, you'll want to have a lab that's very fastidious about following accredited procedures so that the results can be tested, okay? Don't do like the one guy I was talking to southwest of Oklahoma City that would just put a stick in there and lick it. No oil on that, I'm fine, okay? Which, I mean, is a sort of decent measure of hydrocarbons, but not the safest one and not the most accurate one. Oh, sorry, one more point, by the way. Quality and quantity of water. If you're worried about impacts specifically to groundwater wells, you might want to have a licensed engineer perform a flow test on the well to see what its documentable gallons per minute rate is. In a drought, it's hard to explain how much of a change in flow is due to drought and how much of it is due to water being drawn or a change in the formation, but you need to have at least some data to kind of help you out with those claims, okay? How do you get paid for this stuff? Man, I wish I could tell you. And I was talking to these gentlemen earlier. We were mentioning the fact that back in the 1980s, OSU had a survey of landowners to determine what surface damages were being paid in different parts of the state, what was being paid per foot for pipelines. The most recent data I've found in our files is from 1980. So the market's changed a little bit since 1980. I'm not going to put that out there. I think it may be dated. So what I will tell you is try to get as much information as you can from the market. Understand your payment terms. If we're getting a surface damage check and it's for a location, it's probably just a dollar number. But if we're talking about road access, if we're talking about utility lines, if we're talking about pipelines, that may be something per rod or per foot. Understand the dimensions and understand the rate for those dimensions. And know what a rod is, and a chain, and a furlong, and a league, and a kilometer, and blah, 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 right? I don't know why we can't just do stuff in feet. We measure everything in feet these days. We can just use feet. Rods, really not necessary anymore. Think in kind. And what do I mean by that? I want you to take advantage of an element of human psychology here. If I put a dollar number in front of something, your brain sure makes note of what happens after that dollar sign. You start to pay a lot of attention. But if you don't have a dollar sign, if I erase that, now it becomes really hard for your brain to figure out what something's worth. So why am I telling you this? If you need cash, ask for cash. But if you don't need cash, ask for other stuff. Hey, you've got a bulldozer out here. Boy, I sure could use some terraces and a pond. Or you've got some gravel trucks coming through. Could you add a little bit to the road to give me access to this back pasture? You got some leftover pipe. I sure could use that for some fencing. If you ask for stuff in kind, meaning stuff, not dollars, you might be able to get a lot more value than you would have gotten if you just asked for a check. Like I said, if you need the cash, ask for cash. But if you don't, ask for stuff, you might be able to get more value there. And we mentioned this earlier, ask what you can sell them. Do you have services or materials like you can provide, gravel, water, those sorts of things. One other thing I would tell you too when you're trying to figure out what the market, you can talk to a landman, find a landman out there, and say, hey, I'd just like to hire you as a consultant. Could you give me a ballpark for what damages in this part of the world have been going for? Because they do lots of work for oil and gas companies. They're in the know about that stuff. When I was giving this presentation in College Station Monday, somebody asked, hey, Ferrel, how do I find a landman? I jokingly said, well, swing a cat around by the tail and you'll probably hit one. And a guy at the back of the room said, I'm a landman. So, hey, there you go. Any landmen in the crowd? Landmen? It only worked once. Dang it. Okay. I bet you don't have to go too far to find one, though. Since we're talking about water sales, one thing I would tell you, too, with respect to water is make sure that you have the right of access to that water. And as a landowner, you're entitled to the use of groundwater under your property up to a certain amount. It's about 2 acre-feet per year per acre. But that's for your domestic use. Oil and gas production doesn't come under domestic use. So you may have to talk to OWRB to get a water appropriation before you sell water to the operator there. If we're talking about surface damages and we're talking about damage to crops and livestock, in the agreement, just be very explicit and objective about how you're going to determine what those damages should be, okay? How are you going to confirm those damages? If I've got damage to a crop, is it enough for me to take a picture and say, there's an acre of crop down the drain because of vehicle traffic or because of a saltwater spill or something like that? Or do you have to have a certified crop advisor come out? Or do you have to have your, oh man, he ran off on me, your county extension educator come out and do an assessment for you? Some neutral party, right? When you're figuring out how the damages have been determined, let me back up for a second. With livestock, there might be a requirement that you have to have a necropsy performed by a licensed veterinarian. That may be something to think about there too. When you're figuring out what's the cost of this, how are you going to figure out that price? If it's a crop, are you going to ask what the cash price is right now? Or are you going to look at the nearby futures contract? If it's a local cash price, is that price the price of the elevator in Alva or Cherokee or, wherever you might be, Manchester, Cape, who knows, right? But where are you going to figure that out? How do we all know what that number is? If it's livestock, do we look at the price for a comparable animal at the local livestock auction? What if it's breeding stock? Lots of times the animal that's killed as a result of some oil field activity is the best genetic animal that we've ever had on this place. And it's not just some old commercial cow that we were about to send to the packer anyway, okay? So how do you figure that stuff out? Be objective in saying that we're both going to look here, okay? This is a piece of data that you can look at and I can look at, and we can both go, yep, that's the price of wheat for this crop. That's the price of a commercial heifer at that point in time. But we both know what it is. We can look at it. It's easy for us to figure out. You have a duty to pay me if any of those damages occur, and that payment must occur within 30 days of the loss, 60 days of the loss. Or what it might be is 30 days of notification in writing of the loss. We kind of talked about water. Just to go back and mention that point one more time, make sure you have adequate water rights to sell that water. You probably have a right to use that water for yourself, and that's fine. But if you sell it to another party, now we may need to talk to OWRB, the Oklahoma Water Resources Board, to make sure that that sale isn't violating any of their laws or regulations. You don't want to do that. Get permission rather than asking forgiveness, right? If we have arranged for that water sale, define what that payment schedule is going to be. And again, ask around. Especially talk to some of the local municipalities, because they probably buy water from somebody. And they can at least kind of tell you what the area's payment for water has been. Define where the water can be taken from. And sometimes it may be a border agreement. Hey, if you guys dig the well, I'll give you the water for free, but you give me access to the well after it's done, so now I have a new water well. How's that water going to be obtained? If it's from a creek, do we want to define an access point that they're going to gravel so that I don't have lots of mud getting kicked up into the stream? And last, but most certainly not least, know what the water's worth to you. And lots of farmers and ranchers don't think about this, but every gallon of water you give them is a gallon of water you're not using on your place. Do you know what a gallon of water is worth to your operation? Something may require a little bit of a pencil being applied to the back of an envelope to figure out exactly how much is that water worth to you in your crop operation or your livestock operation. Yeah, I'm going to talk about fencing again, but we're talking about fencing or roads or any of that other stuff. In as much as you can, write into your surface use agreement that you get to consult with the operator about where those roads and fences go. And they may not give you total control over it. They probably can't as a practical matter. But they might say, well, let's talk about it. If there's a way that we can route this road to minimize the disruption to you, and hopefully, by the way, pay you less money in damages, right? Okay, let's talk about that. Or if you've got a pivot here, is there a way that we can get onto your place and not cause interference with that pivot? And, you know, I know nowadays the temptation is to say, hey, just use horizontal drilling. You can drill anywhere from anywhere on that. And that's true to an extent, but horizontal drilling's not cheap. Sometimes it may be more expensive for them to use horizontal drilling if they intended to make a vertical well, but that's something we can talk about, okay? We've already talked about fence cuts. You can set specifications for the fencing, like, hey, the fencing needs to be as good of quality as the fencing around it. Or you might say, I'd sure appreciate it if you put better fencing in than the fencing around it. Now, I work for OSU, and I went to OSU. And there's a school down the interstate that I don't talk about a whole lot. But if you keep driving down the interstate, there's a whole nother state. And they have a university, too, that we don't talk about a whole lot. But the thing about that university that's got some kind of scrawny, really tough, eaten cow as their mascot, they own in their trust 2 million acres of land. That'd be nice. And when you own 2 million acres of land and someone wants to lease land from you, you kind of get to say what you want out of that, especially when it comes to the minerals and stuff. So, Texas University has a field manual for anyone who wants to lease or operate on their property. It's got some pretty good stuff in there. So it's got specifications for fencing. It's got specifications for cattle guards, for putting barriers around tanks, all that sort of stuff. It can be a great source of ideas for you. Just bear in mind, if you own less than 2 million acres of land, you might not have the negotiating power they do. And lots of my friends say, well, Ferrel, they've got this schedule of what they ask for when it comes to roads and minerals and all that stuff. And I'm like, yes, they do. and they can set a schedule because they own 2 million acres. Not all of us can do that. Yes, ma'am?
Yes, how you got this field manual?
Excellent question. Just get on the web and do a search for University of Texas Lands Field Manual. And that's one of the resources we'll be posting to our website too, by the way. University of Texas Lands Field Manual. Because technically it's the University of Texas University Lands Office, but putting university in there twice just confuses Google. So, University of Texas Lands Field Manual. Another important thing to throw in there is that all gates will be closed and locked so that other unauthorized people can't be on the property. You need to be provided with a lock and key. They need to have a lock and key so that anybody can get access when they need to. Lots of landowners are including speed limits in their surface use agreements to make sure that we keep things below 20 or 25. That's not just for personal safety, that's also for livestock safety. That can help out a lot there. Maintaining the location, because now you've got this thing that's kind of disrupted the land use in the area. How are we going to maintain that operation? So make sure that we don't do anything to damage the soil profile or cause any undue erosive damage, because if we have something out there that's not covered, doesn't have vegetative cover on it, boy, that water can run off really fast. Here in western Oklahoma, we don't get those nice little drizzly rains, right? We get all of our rain 3 inches at a time, and then it doesn't rain for 2 or 3 months, right? So watching out for soil erosion is very important. Make sure that your location isn't being used as a warehouse. We're not storing a bunch of stuff on your land just for use on someone else's land. That can cause a lot of vehicular traffic that you don't need otherwise, and it kind of makes your place look kind of rough. Speaking of looking rough, no trash or debris on the property. Anything that's trash needs to be put into a container that's got a very heavy lid, because this is western Oklahoma. I feel kind of ironic that I'm not giving you a wind energy presentation today, given the winds I was driving into on my way up here. Weed prevention, making sure that we'll properly spray and maintain the location so no noxious weeds get on there and cause further damage to the land around us. Anybody that's on the property should not have any drugs or alcohol on the property. And you might even want to specify that anyone found with drugs or alcohol in their possession while they're on the property is immediately kicked off, no questions asked. Lots of people also write into their agreements that you cannot have a firearm or fishing pole in your vehicle, and that no hunting or fishing is allowed on the property. And some people have even had to include that there are no social gatherings on the location. One landowner actually had the company have their company picnic on their location. So think about that there. Once this is all said and done, and either the well has stopped producing and it's just no longer in use, or at least the drilling operations have come to an end and now things are going to contract back quite a bit, let's talk about getting all the equipment out there, okay? Everything's going to be removed within a set period of the well being completed and or production being stopped. So a couple things you have to think about. Number one, how long is that period going to be? Talking to the lawyers that do a lot of this work, they said 120 days is about the shortest period they've been able to negotiate on that point. But some have done 180 days, some have done a year. The other point to consider is, how do you know when production has ceased? To an extent, you can look at Oklahoma Corporation Commission records to get the production reports for the well, but that's a lot of hassle. You might ask to be provided with those production reports, and you agree that once production has dropped below a certain level or has stopped for a certain number of months, then we deem the well to have been closed out. Include in your agreement language that says we're going to reestablish vegetation. Lots of operators will include language that says we're going to reseed the operation, but if you don't have proper soil preparation and you don't have water, reseeding equals feeding the birds, okay? That's not really helping anybody out. So when you write in there that you're going to reestablish vegetation, be specific and say, and you're going to prepare a soil bed, and you're going to water, and you're going to fertilize, and you're going to keep that up until the vegetation has been reestablished. If there's damage to terraces, culverts, sediment ponds, anything you've got out there that's a conservation structure, make sure those things get restored as much as is possible. Include an obligation to restore the condition of your property, even if that costs more than the property. Now that may sound a little bit weird, but we've actually had some cases in Oklahoma and Texas where the oil and gas company had caused some damage to the surface. The surface owner said, hey, you said that you would restore the damage to the condition that it was in before, but the cost of doing that would have been more than just buying the property, and the court said, no, we're not going to make them do that. We'd just rather that they bought the property rather than pay more than it's worth. But you can negotiate around that. If that's part of a privately negotiated contract, you can ask for that on your behalf. That's the surface use agreement side of things. Real quickly before we move to the mineral side, I do want to talk about drilling fluid application, i.e. mud. So with mud, if you've got an if you have an agreement with a disposal company to apply fluid to your property, make sure that you have the full legal names of you, but also their full legal name. So make sure you know the company that you're dealing with, which may not be the operator. In most cases, it's probably going to be a separate disposal operator. What kind of samples do you want to have of the fluid before it's applied to your land? Under the Corporation Commission rules, the only thing that they're really obligated to test for if it's a water-based fluid is they have to test for salinity, measured by electrical conductivity. You might see that called EC. And they have to measure, basically, that's a measurement of salts. And they have to measure, now I'm completely losing it, Ferrel, salts and, think pH. If you want to know more than that, you can ask for it. You might want to know heavy metals content. You might want to know if it's got an oil and gas or hydrocarbon content. Because even in water-based fluids, that will sometimes happen. There are also diesel-based fluid or hydrocarbon-based fluids that sometimes get land applied. Those have to be measured for what we call TPH, which is total petroleum hydrocarbons. And there's a an oil and grease measurement. You can ask for more. You might ask for something that's called BTEX, BTEX. That's benzene, toluene, ethylene, and xylenes. Those are some of the more nasty stuff that can sometimes be entrained in oil and gas. You can ask for that. They don't have to give it to you, but you can say, hey, if you don't give it to me, then I don't want to really apply this stuff to my land. Have a map of the application. Have a map of the application area. Again, like we talked about with seismic permits, have an area of your property. Highlight, this is where you apply, and this is where you do not. Again, make it as easy as possible for them to know what they're supposed to do. Now, some of the very sophisticated companies in Oklahoma have GPS sensors on their trucks, and they define a GPS barrier around the property where they can apply. Their trucks only turn on when they're in their fence, and they automatically turn off when they leave. Not all companies have that, but it's a nice thing to ask about. Oh, sorry, duplicate slide there. If you're going to have damages, again, same thing as what we talked about with surface use agreements. Be very specific and clear about how you're going to define how we determine the damages and how they're compensated. What are the payment terms? And at least when I asked the question a couple of years ago, people were getting about 50 cents per barrel for water-based fluids, about $1 for hydrocarbon-based fluids by the barrel. That may have changed given the changes in the marketplace. But understand how it's being measured. Make sure that you have a means of documenting and auditing whether you're being paid correctly. Define what's called a material breach. And there's another one of those fancy lawyer words. Material breach means you did something so bad in the agreement that the deal's off. Lots of times, material breaches in this context might be that you applied in a prohibited area, or that you applied when there was runoff caused and that reached a surface water body or something like that. Notice provisions. Obviously, if there's a legal issue, you want to have notice of that. And if I want to give you legal notice, where do I send that? But perhaps even more importantly, if there's an emergency, there's been a spill, what number do I call to get to you as quickly as possible? Make sure that's a number that you're actually going to check and follow through with. Tenant provisions. And I actually got this question a while back. Someone who was a tenant, someone who had been leasing agricultural land, had their landowner give a disposal company permission to apply fluid to their wheat crop. That made them a little hot under the collar. And that's also kind of illegal under Oklahoma law as well. You can't do that to your tenants. So make sure in your leases, whether you're the landlord or the tenant, let's specifically address whether you can or cannot allow fluids, and if there is fluid application, how is that going to adjust your rent? And then a little something called indemnity, another favorite lawyer word. If there's any damage caused by the application of fluids to the property, operator, you're going to compensate me for that. You're going to protect me if I get sued as a result of something you did on the property. Very critical. Just also understand that an indemnity is as good as the company that gave it to you. Okay? If they're bankrupt, their indemnity is probably not going to help you out a whole lot. But if they're in good shape, well then they're obligated to follow through with that obligation. Speaking of things that you might do in violation of a lease, you can also do that in violation of your crop insurance policy. So very carefully read your crop insurance policy. All of the crop insurance providers that I've talked to said if you apply drilling fluid to insured property, you've just voided your policy. So understand that up front. Talk to your insurance provider before you agree to this if you're going to apply it to cropland, and see what impact it's going to have not only on this crop year, but it might have impacts on future crop years as well. So be very carefully about that and address that in your application. Okay, or not your application, I'm sorry, your agreement. All right. So we have whipped through the surface uses very quickly. Before we move on to oil and gas issues, let me reset my timer. And let me see if you guys have any questions that you'd like to bring up right now on that front. Or I've just blown you away with my incredible knowledge. You have no questions whatsoever. Yes, sir?
Where does the hydrogen sulfide gas go?
Hydrogen sulfide is something that sometimes gets entrained with oil and gas, and when we produce it, that's usually got to be taken out, especially if we're talking about natural gas before it's put in the pipeline. It's really corrosive. So if you've got a well that's known to produce hydrogen sulfide gas, you'll probably use a sweetening unit, which basically uses a catalyst to react with and pull the hydrogen sulfide out before it's put into the gas. And then the hydrogen sulfide is basically pulled out with that fluid and then disposed of. But you definitely don't want that around. Hydrogen sulfide is bad news. Okay, it's really bad because it tends to make you not alive if you breathe too much of it. So oil and gas operators are very sensitive to that as a safety concern. They'll have hydrogen sulfide detectors on their rigs to make sure if they've hit a pocket that they can quickly evacuate everyone. But you want to make sure that you provide notice to the landowner that, hey, we hit a hydrogen sulfide rich deposit. We're going to provide emergency notice to you as well. So again, make sure that they know how to contact you in an emergency. Have that cell phone number accessible to them in case they need to reach you. And when they call, you might want to answer. I've got some phone numbers. I'm like, oh, it's that person. I'll let it go to voicemail. When the oil and gas company calls, you probably want to take the call. It might be something pretty important. So good question. Anybody else? Yes, sir.
So what happens if you sign a lease with a company and that company goes belly up, and in the process of going belly up, somebody puts a lien against that company? Does that lien then impact your surface lease that you have with them, and if so, how so?
The question was, if we have an oil and gas company that has we're talking about surface use agreements, at least for right now. You've got a surface use agreement with someone. They go bankrupt. So obviously their creditors are going to be trying to secure liens on their assets. Does that impact the surface? Generally, it should not, because you are basically operating with them under an implied easement. So from a legal technical standpoint, the only relationship that you have with them is that they have permission to be on your property. Might that lien impact the equipment that they have on your property? And the answer is absolutely yes. Yes, but there should be no legal connection between you and them that permits a creditor to place a lien on your underlying surface. So that's a very good question. Now, remind me of that question again when we talk about minerals in just a second, because it's a little bit different. Not that they're going to have a lien on the minerals, but they might have a lien on their interest in the minerals, and that's a little bit different. So hold that thought, and we'll talk about that one. Yes, ma'am.
Well, my question is, if you have a lease, the creditor who filed the lien does not have access to the provisions of your lease?
Now we're talking about leases and not surface use agreements, so hold that thought. Let's talk about mineral leases here in just a second. But you're on to something, and I want to follow that train of thought here in a bit. Someone in the back have one? Nope. Okay. All right. Well, let's talk about the oil and gas lease side of things. So like we talked about, in Oklahoma and virtually every other state, you can separate who owns the minerals from who owns the surface. So if you own the minerals, what do you own? You know, you own what we would talk about in law school as being a bundle of sticks, really. Each of those sticks representing a right with respect to the minerals. And the thing about a bundle of sticks is that you can take the bundle apart, right? And I can give you one stick, and I can give you one stick, and I can give you one stick. So what are the sticks? Number one, that you have the right to produce the minerals. In other words, you have the right to drill down and pull the minerals out of where they are. But you also have the right to execute a lease. We call that the executive right. And the executive right is one of the rights that's very frequently pulled off and given to someone. You might have one kid, for example. If you're giving your kids your minerals in your estate plan, you might give the other kids co-equal rights, but one of the kids you give the executive right, meaning they're the ones that negotiate and execute the lease. They alone have the power to sign it. If you had an incredibly good-looking lawyer for one of your kids, for example, you might give them the executive right to that kind of thing. The only problem with that in my family is that my other sibling works in the oil and gas industry, so he's got a pretty good bid on that aspect too, right? The right to bonus payments, and bonus payments are what we get for an advance on the lease. You can assign who has the right to the bonus payments. Delay rentals. Sometimes we act like a well is producing oil and gas, even if it's not, although technically that's a shut-in royalty. Delay rentals might be if we don't want to drill a well quite yet. We can pay delay rentals. That's one right we can split off. And, of course, the right to receive the royalty. And the royalty is simply the share of the production that you get. But usually you don't get that in gas and oil, although some leases actually say that you can. Some folks, especially if they have irrigation pivots on their property, may actually ask for the gas in kind. So they actually get a share of the gas and they use the gas to power their irrigation engines. It can happen that way. Not always, but sometimes. And some people ask for the oil and they market it themselves. For most of us, though, that's kind of impractical. And so when we get a royalty, we say, hey, that's okay. You just sell the stuff. I'll take the cash. All right? So let's look at an oil and gas lease. And by the way, I know you're not going to look at it because that's insanely too small to see. So when you get your oil and gas handbook, and I just looked at it today, it's much easier to see. It's very easy to see there. They've done a great job in formatting it in the book for you. But let's look at a lease real quickly. You might see the parties, okay? That's probably the first thing that you see. You might think, well, that's the biggest no-duh part of the lease, right? Well, with the parties, you need to make sure that it's actually the people that own the minerals. So if that's you, okay. But if it's you and your spouse, that needs to be on there. If it's you and a co-tenant, if it's you, not as you, but as a trust or a trustee or an LLC or a corporation, that needs to be on there. You also need to see who's the operator, who's the person that we're giving this lease to, because that's going to kind of matter somewhere down the road. Make sure the parties are on there, obviously. The granting clause. This is the meat of it. This is where you're giving an interest in minerals, and the minerals underlying this piece of property to the operator. Don't overlook the definition of minerals. Minerals can have a lot of meanings under Oklahoma law depending on the context and how the title to that property has changed over time. But you can have the ability to specify, are you talking oil? Oil and gas. Oil, gas, other hydrocarbons. Oil, gas, other hydrocarbons, and sulfur. Because sulfur is something that we sometimes produce, and that has value itself. Is that part of the oil and gas? Is it not? Out in the far west part of the state, as you go into the Panhandle and into Texas, one thing lots of people exempt from there is helium. Because sometimes helium is produced along with the natural gas. Helium's pretty pricey these days, and they might want to separate out helium under another agreement. One other thing that may strike you as a little bit weird is uranium. Because uranium often is mined in what we call solution mining, which means we drill a hole, we pump fluids down that dissolve the ore containing the uranium and flush it back up. So we can produce it out of a well just like we can produce oil and gas. Uranium's kind of pricey these days too, so you might want to have a separate lease for that. But be careful about how you define the minerals, right? And confirm that you actually own the minerals. We've talked about that a little bit earlier on. Confirm your title before you execute the lease because you don't want to be signing up for something that you don't own. Another thing that you might need to watch out for, especially when you're talking about the legal description of the property, is what we call the Mother Hubbard Clause. The Mother Hubbard Clause, and I'll just show you an example real quick, says if you own land that adjoins what we're leasing, or specifically if you own the minerals that adjoin the land that we're leasing, you include that in this lease. Now, what that's meant to do is to protect the oil and gas company from errors that they made in the legal descriptions. You know, if they left a little sliver of land out that they meant to include, we'll suck it back in there. That's what it's supposed to do. But in certain circumstances, it could be read to say any land that you adjoin along the lease, that's included as well. So let's say you own this, quarter section of property right here. You meant to lease the west half, but because there's a Mother Hubbard Clause in your lease, technically you leased them all the land that adjoins to you. And that may not have been what you intend to do. So lots of mineral owners would say, hey, let's strike the Mother Hubbard Clause. We don't need it. Let's just do a good job of the legal description and move on with life. Here's what we call the Habendum Clause. Woo! Scrabble word, if Scrabble allows you to use Latin. Latin is what habendum comes from, and it simply means this person to have. So what is this person getting? What they're getting here is that they get the right to use it for 3 years, in this case, a 3-year what we call primary term, and then for so long as oil and gas or either of them is produced from said land by the lessee. That's what we call the secondary term. What this means is that from the date that we execute this lease, the oil and gas company has 3 years to start producing oil and gas. If they haven't started producing oil and gas by that point in time, lease is over. But if they are producing oil and gas within that 3-year period, they get to keep the lease for as long as oil and gas is produced. That could be a long time. There are some leases in eastern Oklahoma that have been held by production since we were a territory, and they're still in place in 2016. So that could be a really long period of time. By the way, some leases will say that. Some leases will say for so long as oil and gas are are produced in paying quantities. Paying quantities generally means they're producing enough oil and gas to cover the costs of operating the well, which that doesn't necessarily mean a whole lot either. So this, in addition to the royalty clause, is probably one of the most important terms in the lease. Understand what the primary and secondary terms are. Lots of landowners and lots of attorneys feel pretty uncomfortable signing a primary term longer than 3 years. And depending on the level of activity in the area, that number might shrink up some more. So be sure that you understand what that primary term is. And sometimes oil and gas companies will ask for an option. An option's not a lease. An option gives the operator the right to give you a lease later on, but they don't have the obligation to do it. And the trade-off to that is that while there's an option on the property, you can't lease the land to anyone else. So some people are uncomfortable with options. There are lots of things that people do to limit or to kind of define the habendum clause. One thing is a depth clause, and you probably have seen something like this. This clause right here is an example of how you would define the depth of the well at its lowermost point. In other words, if ABC Oil Company drills to, 5,000 feet, then as the mineral owner, you have the right to lease any of the minerals below that formation to someone else. Some people get really creative and allow it to include upper depths as well. In other words, oil and gas company, if you drill to this formation, then this lease just applies to that formation. And if there's another oil and gas formation above or below, I can lease that to somebody else. The royalty clause. This is probably what you guys are somewhat interested in. I mean, if you don't want any money out of this thing, you can ignore this part of the presentation. But if you would like to get some money out of your minerals, this is what you kind of care about, right? And we all see here this number 3/16, 3/16, 3/16, because that's just what it is, right? It's 3/16. There's nothing magical about that number. It tends to have been the market number in Oklahoma for a while, but it could be an 1/8, it could be a 1/6, it could be a 1/5, it could be a 1/10. It just kind of varies. In Oklahoma, we trend around 3/16, so that's what you kind of tend to see, but it's not written in stone anywhere. So this is what we're basically giving you in terms of the production. Like we said, we could give you 3/16 of the oil or 3/16 of the gas, but sometimes that's kind of impractical. So we sell the oil or the gas, and then we give the landowner 3/16 of the revenues from that. Read this stuff very carefully. How is revenues defined? What stuff do they take out before they calculate what's revenue? That's huge, okay? What are those allowable deductions? And we've got tons of cases in Oklahoma on this that talk about, well, is it measured at the wellhead? Is it measured when it goes to market? Do we take out dehydration, desulfurization? You name it, right? And we don't have time to go into all those different elements today. All I'm going to tell you is understand and be very clear about what deductions are allowed. Now, we said that we were going to give you a 3/16, in this case, royalty out of what we got in gross revenues from selling the product. Now, the operator in this model lease is Petropokes. Well, what if Petropokes is wholly owned by Polk Enterprises? And they sell the oil to Polk Enterprises at a deep, deep, deep discount to what the market should be, because they're a wholly owned subsidiary of Polk Resources. You'd probably say, that feels a little to me. I would like to get what the market price is. So there are several cases in Oklahoma that provide protections to the landowners against that kind of thing. I like to be explicit about it. So you might want to consider what we call an arm's length transactions clause. That says, if you sell your oil or gas to someone who's not an arm's length party, it's someone that you're affiliated with. You might also see this called an affiliated parties clause. If you're selling it to someone who's not at arm's length, we're going to get the arm's length price. Look at the open market. That's the price that we're going to use to define our royalty, not what you sold it to this affiliate for. Shut-in royalties are another element of the royalty clause. Remember what we said. Almost all leases say that the secondary term lasts as long as oil and gas are being produced or are being produced in paying quantities. What if, I don't know, hypothetically, the natural gas market just went in the tank? I mean, what if the prices were just gosh awful, like we hadn't seen in years? I mean, can you imagine a world where that would happen? Right? Yeah. Okay. It's not that hard to store oil. You have tanks for that. It's darn hard to store natural gas. The easiest way to store natural gas is in the ground before you pumped it in the first place. So that's how we want to store natural gas. So if a company says, hey, we'd like to wait for a little bit until the market gets better to sell this, we're going to leave it in the ground. But if they're doing that, they're not producing oil and gas, and they run the risk that their lease would lapse and someone else would get a heck of a deal. So what they might include is a shut-in royalty. That says, here's what we're going to do, mineral owner. We're going to pay you a certain amount per mineral acre per month or per year, whatever the case might be, and we're just going to agree that we're producing gas. Wink, right? If I pay you this, you agree that the lease stays in place. Okay, that's fine. Just make sure that you have a reasonable amount being paid that you're comfortable with. Some people also like to include a clause in there that says, hey, that's great, but if there's another well within a certain radius of where we are that's producing gas and selling it, you're not shut in. Okay, you're doing it because you want to, not because the market's demanding it. So you're not going to be shut in at that point. Another thing people might include with their shut-in royalties is that you can only pay them for a certain number of months. Some people might define that in terms of consecutive months. Some people define it in terms of cumulative months. So for example, consecutive might say, you only get to do this for 24 consecutive months. You are a really popular man, sir. So You can do it for 24 months consecutively, and if you do that, we're just going to call the lease off. Or if it's cumulative and it's 24 months, that can mean 6 months here, 6 months here, 6 months here, 6 months here. Now it all adds up to 24 months. Boom, the lease is terminated. Another clause you might see is called a commencement clause, which is kind of paired to what we would also have as a delay rental clause. Remember our primary term. You got 3 years to start producing oil and gas. Lots of oil and gas companies get really nervous about this. And so what they say is, well, we've got 3 years to begin drilling a well. Now ask yourself, what does it mean to begin drilling a well? Does that mean that I have a bit turning in the ground, making a hole? That sure sounds to me like beginning to drill a well. Some leases say, if I had a surveyor out there and stuck some flags out there and I surveyed the location, well, that's me starting to drill a well. Where's the right answer, right? So you might include language that says what starts drilling a well. So, for example, you might have a commencement clause. This commencement clause says drilling a well means you've got the rig on site, and that rig is big and bad enough to be capable of drilling to the formation you want to get to. That's a pretty serious commitment on the part of the oil and gas company. If they've got the rig there, they're not going to do that on a whim. That rig is costing them money to be there, okay? So that might be a good one. Or you might also say actual drilling. Like you need to have a bit making holes in the ground. That's drilling a well. But you can define that. You don't have to leave it up to what the implications are. Pooling and unitization. Whoa. We could talk for days and days and days about this, right? So let me make this fairly straightforward. It could be that on 1/4 section, 160 acres of ground, I might have 8 mineral owners. I could have more, by the way. And it would be pretty inefficient if I had to drill an oil well on every one of those leases. But I'd be required to do that to produce those minerals. So what we decided a long time ago is like, look, let's try to be as efficient as possible in producing minerals. Let's try to minimize how much we disrupt the surface, and let's try to be as fair as possible to all the mineral owners at the same time. So the Corporation Commission has the authority to do what we call pooling or unitize areas. And essentially what that means is that we take a bunch of different mineral owners, put their property together, and act like they're one mineral owner. So one well can produce everyone that's in a pool or a unit. And again, I'm skipping a lot of stuff on this, so I'm kind of oversimplifying it. But we treat that as being one unit, okay? One mineral owner. And the minerals that are produced from that unit are then attributed to everyone in the unit in proportion to how much of the unit they own. That concept that I just talked about is going to be important here in a minute when we talk about division orders, because that's meant to deal specifically with that. So, it's not that pooling and unitization clauses are bad in and of themselves, but you have to be careful about how they act sometimes. For example, let's say I own a piece of land. Part of the land is inside the unit, part of it's outside. Well, production of oil and gas on the part of my land that's inside the unit, depending on the terms of my lease, might act as production on the part of my land that's outside the unit as well. So if someone else came along and wanted to lease the part of my land that's outside the unit, I can't do it because it's held by the lease inside the unit. That's where we come up with a pew clause, okay? What does a pew clause do? And by the way, it's P-U-G-H, not P-E-W, right? Or seat at church, P-E-W. Pew just comes from the name of the case that validated this clause. A pew clause says that if you're producing oil and gas from a unit, that only holds the part of my land that's inside the unit. It can't hold the part of my land outside the unit. Now, Oklahoma has a statutory pew clause, and it basically does this for land with a grace period of 90 days. In other words, a unit lease can't hold land outside of it for more than 90 days. Most people include a pew clause just to make it 0, okay? So if they need to lease to somebody the next day after the lease expires, boom, they've got it, okay? The warranty clause. Sorry, I'm drying out here. People focus on the granting clause. People definitely focus on the royalty clause, and they never look at the warranty clause. This thing can get you in more trouble faster than any other sentence in this lease. Look at the top one. Lessor hereby warrants and agrees to defend title to the lands covered by this lease. What you're saying is that if there is any flaw in the title to these minerals, I'll defend you, oil and gas company. I'll fix the flaw at my own expense. That's awfully noble of you, Mr. Mineral Owner or Mrs. Mineral Owner. They have a landman or a land company. They could have done the title work. They should know the condition of the title. Why are you warranting that for them? So, what I'm a much bigger fan of is the second line. Lessor only warrants title to the land covered by this lease by, through, and under lessor and not otherwise. Again, legalese, I can tell some of you are starting to glaze over. What's the difference? This is saying, I'm not warranting title back to the dawn of time. If you read Oklahoma land titles, they might go back to, territory or the land run. Any flaw in that title, that could be on you. What you're saying with the second clause is, I'm telling you that since I acquired these minerals, I haven't done anything to create a cloud on that title. I haven't granted them to someone else. I haven't mortgaged them. I haven't spun them off. It's all mine. And if there's a flaw in the title that came along after I got it myself, okay, I'll defend that. But I'm not defending any defect in title that came along before I did. Very important distinction there, okay? So lots of landowners just flat out strike the warranty clause, but some in negotiations will add that clause back in. So that's the stuff that's in the lease. What's not there that should be? How can you fix that? Well, one thing lots of people say is, hey, there's nothing in here about a bonus. I was supposed to get a bonus. Why isn't that in here? Well, the bonus is never going to be made part of the lease. It's always going to be part of a separate contract or document, maybe a letter of intent. But it's always going to be separate from the lease, so it's not in there. But you, by gosh, need to make sure that it's in writing and signed by the operator or the lessee. Everything in writing, everything signed. And by the way, since we're talking about that, when you're trying to document your communications with someone, everything's in writing. And here's how far some people take it. I've had some people that I've talked to say when a landowner comes to my house and says, hey, we'd like to lease your minerals, they say, would you please leave the packet with me? Thank you. Have a nice day. And that is the last oral communication they have with them. Everything else is by text message, email, or letter. So that every piece of communication is documented in writing. Now that's kind of an extreme position, but it works. Okay, you definitely have a paper trail for stuff. So just consider that everything needs to be documented in writing. If you're the mineral owner that also owns the surface, remember, all that surface stuff needs to be written into your lease. Okay, protect your surface rights also. If you've got some changes that you want to make to the lease, you start out just getting a pencil like, well, let's scratch through that, let's add this stuff in, and pretty soon you can't read the lease. Okay? So what's probably preferable is that you execute some sort of an amendment document. You might see that called a rider. Some people call it an appendix or an attachment or an exhibit. But whatever it is, it's simply another page that references, or pages, by the way, that references back to the lease and says, this lease is modified in this way. You can have your attorney document that for you. It's nice, it's clear, it's easy, everybody understands it. Just make for darn sure two things. Number one, that both parties sign the amendment. It's no good if only one of you signs it. They both of you need to sign it. Number two, that there is something on the face of the lease, written on the lease itself, that refers to the amendment. Okay? You need to have some signal on the lease that says, hey, by the way, this lease isn't all. Look at this page. It's part of this lease as well. So be very clear about that. So we've talked about the anatomy of the lease. Let's talk about some other points that we haven't really had an occasion to deal with yet. Know who you're dealing with. Are you talking to somebody who is working for the developer? You know, some of the big operators have their own land departments. And so when you're talking to their landman, you're talking to the company, a representative of the company. But then there may be landmen that are hired on contract, and some land may be speculators. Dirty word, right? Speculators. I'm not saying speculators are bad, but they're probably not directly in a relationship with an operator, so they may not have the authority to talk for the operator. So know who you're dealing with. And the way to do this is, number one, ask questions like my son. Okay? And God bless him. I'm so glad he asked questions, because I was a question-asking fool when I was his age, and it helped me understand a lot of how the world works. So stay curious, kid. But you stay curious too. Ask lots of questions. Grill, grill, grill. Like Sarah Palin might say, grill, baby, grill. You know, ask them every question you can think of to figure out who do they represent, what are their intentions, what are their real goals with respect to drilling. Is this something in the near term? Is it something long term? Ask lots of questions. And ask them, who are you representing? Are you acting on your own? Are you trying to put together packages to sell to somebody else? And I'm not saying that's a bad thing. I'm just saying helps you to know, right? Or are you dealing directly with the company? Okay, do you have the authority to act for Petropokes LLC? Is the operator committed to drilling? Is this something that says, hey, they're going to drill within this 3-year period, or they're just trying to stockpile leases? Again, not saying that's inherently bad, but it may affect your decision as a landowner. Ask for references. Who else have you dealt with in the area? I want to go talk to them. And then find out who that person is, and then ask them if they know someone else that they've dealt with. You get good stuff from direct references, but those are people they picked out for you to talk to. You get the real dirt from the indirect references, okay? So the people that other people have told you to talk to, that's where you get the good stuff. Know your bargaining power. And if only it was that easy, right? How do I know what my bargaining position is? That's the point of all negotiations. But here's some things you can do. Number one, know the amount of mineral acreage that you own. If you own all of the minerals, 100% of the minerals, under a quarter section of land, that's a pretty decent place to be in. If you own an undivided 1/128th of the minerals under a section, your bargaining position's lessened somewhat, right? But know what you own. That goes back to knowing what you have with respect to the minerals, and that mineral abstract becomes pretty important. Know how close you are to an actual producing well, because all other things being equal, the closer you are to known production, the better the odds that your production is going to make as well. And then how many people are competing? The more competition, the better prices tend to be. If there's no competition, create some. If you get an offer from one company, take it to another company and say, hey, I got this from this guy. Would you be willing to match that? Create competition. We economists say it's a good thing. If you can, try to increase your bargaining position. You can get together with other mineral owners. There's lots of ways you can do that. Farmers Royalty Company is one company that negotiates on behalf of all of their mineral owners, because all the mineral owners basically pool their minerals with the company. Mineral auctions are another way that you can improve your bargaining power. That's pretty important. That takes some organization with some other landowners, but again, you can do it. How do you get paid for this stuff? And I know I'm getting dangerously close to a break, okay? Be specific about where your payments are made, how frequently they're made. Be clear about what you can and can't deduct for processing the oil or gas. And be very careful about the division order that you sign. So let's talk about division orders. The lease giveth, the division order taketh away, as the saying goes. What's a division order? If we put a bunch of mineral owners together into a pool or a unit, we're giving them a fraction of the production from the overall unit. So what we have to know is what fraction of the unit do they own. What a division order is, it's you stipulating what fraction of the minerals you own. You're agreeing to that. So that provides protection to the oil and gas company. If we pay you according to what this division order says, we're good. We did what you and I agreed was right in terms of paying the fraction of the minerals that you own with respect to the unit. And if you can see this, you would see that our landowner here has 0.0002925675 of the royalty interest in this unit. Where did we get that number? That's 3/16 of an interest royalty on one net mineral acre. Okay? So your number may be different. All we're saying, though, is that if you sign off on the division order, understand you're agreeing that they're right about the number. So you need to confirm that they're right about the number. Now, if there's a conflict in the language of the division order and the language of your lease, odds are you sign the lease first, then sign the division order. The division order would control in that circumstance. So be very careful. You might include language in the lease that says any subsequently executed division order will not contradict the terms of this lease, and if so, the lease controls. Heck, I would add that language on the division order that says if there's a conflict in the terms between the lease and the division order, lease controls, right? Don't negotiate something with the lease, then give it away in the division order. Talked about knowing your fractional ownership. Read for conflicts, make sure they're not there. Now, one thing that they're going to ask you for, either in the bonus contract or with the lease or as part of the division order, is your Social Security number. Because there's this little agency called the IRS, and they tend to get really uptight about getting what they're entitled to. So the oil and gas company has to report royalties that are paid to the IRS. To do that, they need your Social Security number, okay? But do not put your Social Security number on the lease. Do not put your Social Security number on the division order, because those things could wind up in public records. And you don't really need everybody knowing your Social Security number. That's how identity theft happens, right? So do not put it on the lease. Don't put it on anything that will be recorded in public record. So if they ask you for it as part of your bonus contract, or they ask you for it as part of your division order, whatever the case might be, you can include a W-9 form. But don't put it on the document, and furthermore, don't staple it to it. Don't attach your Social Security number to anything that might wind up getting filed, because sometimes stuff happens, okay? So make sure those are kept as separate documents. Just make sure that your Social Security card that looks like this doesn't show up somewhere else winding up looking like that, okay? So keep that stuff separate. Real quickly, I'm running out of time. I'll be fast. You'll see something in your lease possibly called force majeure. That's French. In algebra, they use letters to mess you up because there's not enough numbers to do it. In the law, we use French and Latin to mess you up because there's not enough words for us in English, apparently. Okay? Force majeure is stuff that allows them to suspend their obligations under the lease. Hey, stuff happened, it's out of our control. We don't have to do what the lease says until that circumstance goes away. So all I'm going to tell you is be very careful in how that's defined. Try to make it stuff that is legitimately out of their control. Acts of God, out of their control. But market conditions, although out of their control, are also things they can do something about. They can hedge. They can manage risk. So market conditions, I would argue, aren't very good force majeure provisions there. Reading your lease, minorly important, right? So, read everything, get everything in writing. Have an amendment if you don't like what you're seeing there, right? And you might actually hire a lawyer. I know people like hiring lawyers exactly as much as they like hiring plumbers and like paying them even more, right? But if we're talking about something that might be worth tens or even hundreds of thousands of dollars over its lifetime, man, it might be worth hiring somebody that knows what they're doing to write this stuff up for you. And by the way, I'm not drumming up business for myself. I took an oath of poverty when I joined the university, so I don't get to have clients in Oklahoma anymore. But it might be worth it, right? Ask them for their oil and gas experience. Ask them for references. Be very clear about the work that they are and are not to do and how you're going to be charged for that. Get all that stuff up front, okay? Last, but most certainly not least, make sure that you have time to adequately review this, okay? It's going to take time. If someone says, hey, I'm passing through, and if you don't sign this today, I'm moving on to the next guy, then go, bye. If someone's not going to give you the time to review the lease, there's something there they don't want you to see, okay? So make sure that you take the time to do that, all right? Make sure you have plenty of time to do that. Make sure you preserve the right to audit your lessee. Do your homework on them. Talk to the Corporation Commission. Talk to the Secretary of State. Talk to the Better Business Bureau. Talk to the CIA, Coffee Shop Information Agency. Just take everything you hear there and adjust it a little bit. There may be a slight baloney factor, so just make sure you take that into account. Okay, with that, we didn't have time to get to the pipeline rights of way stuff. I apologize for that. So very quickly, we'll come back and we'll do a supplemental presentation on that for you if you like. Check the website. We'll have a video of that presentation there for you. And we'll also have a whole chapter in the book for you if you download that on negotiating those pipeline rights of way. I apologize for that. We'll want to make sure that you guys have time for a break. And then we have time for Dr. Hallahan. We'll take a couple of questions really fast. That guy that I used to work for. Yes, sir.
It's really not a question, but a comment. Make sure you initial every page of your lease. I had one changed on it.
What he's saying, just so we have it for the video record, just make sure that you initial every page of the lease to show that that's been reviewed so that nothing gets slipped in there afterwards. Excellent point. Yes, sir.
A while ago you mentioned something called a oil and gas handbook.
Yes.
Where do you get it?
Go to the OSU website, agecon, agecon.okstate.edu. And if you'll go to our extension tab there, we've got links to our extension resources, and you'll find it there. It's in the process of being made pretty so that we can stick it out there and make it easy to print off and format for you. Check it out there, and we'll also have videos of our presentations there as well. Yes, ma'am.
Yeah, one full time.
Would you give it to me once more?
Oh, sure, absolutely. AgEcon, that's AGECON .okstate, OKSTATE.edu. And then once you get there, go to our extension tab. And that has links to all of our extension resources, including our oil and gas stuff. So check back. We anticipate that it'll be posted up there hopefully in the next few days. Oh, it's just our oil and gas leasing handbook. And I apologize. I wish we had more time to present it today. By the way, one of the things that we'll be posting there is videos of these presentations, and we'll also have the video of the pipeline presentation, because I know some of you guys came for that information. I'm sorry that we ran out of time to do that real quick. But we'll have that presentation posted there for you as well.
And those are all on the same site?
On the same website. Yes, ma'am. All right. With that, let's take a break. We'll get Dr. Hallahan a chance to get set up and come back, and we will talk about seismic issues. Oh. You're a very kind audience. Thank you. Thank you. Thank you.